leave that location up and running, just even though there's a sting, even though there's arrest, even though there's a problem, even though we found some issues, we're going to let that continue to go until the court process has fully played itself out. Surely you're going to say, no, we're going to do our investigation, we're going to put our hearing up, and we're going to have our evidence. If we need to call witnesses, we're going to do what we need to do to make sure the public's safe and this place does not continue to operate, right?
Yes, and this issue comes up frequently.
But I mean, when's the last time why couldn't you call a witness in the warrant? Why couldn't you call the officer or a witness or anybody else or the victim in this case? Why couldn't you call them within 120 days?
Because they were instructed by the prosecution not to testify prior to the criminal hearing.
You have a victim that is instructed by the prosecutor not to testify?
Not a victim, I'm sorry. It was a investigator.
Okay, so you have an officer that's instructed by the prosecutor not to testify. Have you requested to see the prosecutor's files?
In this particular case, well, that would be a little bit difficult because of the Attorney General's office.
Okay, so the Attorney General's office, well, this is a whole different ballgame where it's now. The Attorney General's office is the one that's actually prosecuting the case?
Correct.
Where do you work?
Attorney General's office.
So you can't ask somebody down the hall from you, can I look at your file so I can know the evidence of this case?
Not for the civil division. I'm in a different division.
You can't ask because you're in a different division, or you can't ask because you don't know who's doing it?
No, I can ask, but...
Did you ask?
Yes.
And they refused?
They were still determining whether or not they were going to move forward with the prosecution, and the case eventually was transferred back to Shelby County. And we have communications to all prosecutors that are working the case, and we have asked, and we always ask, that if there's ever a plea deal or anything along those lines entered into, that they include not having the license. Now, this person was in jail.
Okay.
So they weren't going to be doing any massages.
So, but again, the Attorney General's office decided not to pursue the prosecution.
Correct.
And at no point did they say, okay, now here's the files that we have. Here, I'll let you look at this evidence. Or you didn't ask to go back after they decided not to pursue the prosecution.
They transferred those files to the DA.
Did you ask the DA if you could see those files?
Yes.
And what did the DA say?
They were not ready to turn the files over until they prosecuted the criminal case.
So it's going to be the policy of the board that even though there's an arrest, even though there's something that may be undue occurring at these locations, this board is taking the position that until there is a conviction, be that 3 years down the line, 4 years down the line, from whatever you have to have, that person can continue to get their license.
No, what we do in these situations is, let me give you a better situation. Let's say that the person was still operating in the state of Alabama, where we have jurisdiction. Mm-hmm. At that point, we would do an emergency suspension as long as we had enough evidence to prove what happened. And generally speaking, we do, because I would say, I don't know, probably 80-90% of the time, our investigators are in on the sting or on the raid. In this particular case, the raid occurred an hour and a half before our investigators could join. Had our investigators been able to join that, they would have been able to testify, because they would have been a separate board witness that was not critical to the district attorney's case.
Okay.
And I'll be glad to provide you a list of licenses that we have either had surrendered, or there has been cases where we did an emergency suspension. I'll be glad to provide that list to you.
Well, let's go further down the line. If you do schedule a hearing, and someone, like if you schedule a hearing for this person, and this person is in Georgia, and this person does not attend your hearing, because you're waiting for this person to come back to Alabama, this person does not attend your hearing, due process doesn't really affect the fact that that person's not there, correct? Like, you could go forward without that person's presence, right?
That is correct.
Okay. And y'all haven't tried to go forward without that person's presence?
Well, without knowing whether or not they're going to show up, we have to have a case to present.
You can't use the Mr. Chairman, but you can't use the information that the police department provided for you and the sting that they did and the history that they've put together for you already. Now, I know the individual has already left that's licensed, but again, it clearly states, I mean, the purpose and authority, the first paragraph in this whole thing, man, talks about establishments too. You hadn't shut down an establishment at all. And things are still happening over there that they're still having to watch in my hometown. And again, this is one. Y'all have shut down other ones, and I appreciate that. And I thank you for that. But there are other ones that y'all haven't done either, and that's not right.
Let me jump in and ask you a question. So and I don't know the answer to this, but from an administrative side, if a license is revoked, there's the automatic appeal to the Circuit Court in Montgomery County. If a Montgomery County judge determines that, there was no due process there, or not enough information to revoke that license, has jeopardy attached for that specific instance? Do you know?
Only for the action that was taken against the license.
Okay, so you could come back then and reinstitute the same thing, basically go through that same process again. Whether it's advisable or not, it's a different story, but in theory, you could relitigate or have that same hearing on the license revocation again.
It would probably depend on timing and whether or not that license was renewed or renewable at that point. If it was I would not think that the license would be renewed, assuming that it had expired during that time. And you would have the hearing then upon reapplication for license, because denial letter, and the denial would also come with an opportunity for a hearing. So again, could request the hearing, and then we would have to represent our evidence again based on that denial.
But you see what I'm timing of those things would seem to be important, that if you were wanted to be proactive, set that hearing. If there's no appeal, and I don't know what the appeal times the circuit court would be under that administrative code, whatever, but if there's no appeal, then it's over and done with. If the court does say that you didn't have enough to revoke that person's license, sounds like a renewal. If that license expired during that time period, there's another step that the board could take to look at whether or not that person should be renewed, not revoked, but renewed. I think there are lots of different tools there potentially available.
If you have the hearing to revoke the license and the person appeals to you, appeals to the Montgomery Circuit Court, that would indicate that person that made the appellate process is intending to keep their Alabama license, correct?
Correct.
Okay, so if the person is intending to be in Georgia and has no intention of coming back to Alabama, generally you would expect that person would not appeal that ruling.
You just never know.
Or show up, or come back to Alabama.
Well, to the extent that there's an active warrant out, that person may not want to come back for that hearing or to appeal. And again, we're talking general terms here. You never know what that individual will do, but I think you could press that issue. Certainly, to the extent they showed up for a hearing, if there's an active warrant out there, you can notify law enforcement that we expect this person may be here and to execute a warrant. Whether or not they're, do that's a different.
Mr. Chairman,
Yes, ma'am.
there's this thing, I guess I just want to, looking at the significant issues, and I just like for someone to address, and I'm just going to do them all at once. Some of the things we've already talked about, and I don't know if this is specifically on yours because we've already taken care of some of them as far as the sexual issue, which was under 8, I think. But I would like, and maybe we've sort of addressed this issue about executive director issuing licenses without board approval in non-emergency situations. And we can just kind of take them all at one time and wherever you all jump in. Executive director issuing licenses without board approval in non-emergency situations.